Good afternoon and a very big welcome to the next Your Employment webinar in the series, providing you with essential employment law and HR updates. For those of you that are new to our webinars, we are of course Jones Chase, a firm of specialist employment lawyers, and we act for a number of companies from PLCs all the way through to startups and also for some fantastic individuals as well. And we have a very high success rate of looking after those that we represent. In terms of the format for the webinar, if you want to ask us questions, please do, and feel free to do so. You can use the Q&A box. If you want to ask questions anonymously, there's an anonymous button that you can hit as well. If you don't mind your name being displayed, you can use the chat box, and we'll be keeping an eye on that as well. And it's really good for us if you can select the drop-down menu and hit the all panelists and attendees for both the Q&A box and the chat box, so everyone can see what you're asking. Just helps us to keep the chat flowing. I should add that we're recording the first part of the webinar to allow us to distribute it to those that couldn't make it today. So please do bear in mind if you're asking questions on a non-anonymous basis, because people may be able to see your name. And I should emphasize that the points we're covering today are not formal legal advice, so therefore please don't rely on this webinar for formal legal advice and just drop us a line instead. And lastly for me, because you can probably hear my voice is going, a quick reminder that the information we're covering today is accurate as of the 1 o'clock on the 14th of December. Things in employment law change very quickly, so do drop us a line if you have any further questions. And today's webinar, we have two parts. So we will be covering the key employment law developments for 2023, and we've got 4 fantastic speakers here to do that. And then the second part of the webinar, where we will stop recording, is the live Christmas quiz. So please do stay online to participate in the quiz. And again, there's some prizes there. Okay, so moving quickly on to the content, I'll hand over to Susanna, who's going to speak about some amendments to the Equality Act, amongst other things. So over to you, Susanna.
Thank you, Dean. Hello, everyone, and Merry Christmas. So I'm going to start off being slightly controversial, I think, looking at 2024. And what I wanted to do was to highlight what I consider will become a potentially new and quite possibly frustrating new era of employment litigation. And I don't want to set the cat amongst the pigeons, but I do think that HR professionals need to start 2024 with their eyes really quite wide open. So why am I saying that? Well, from the 31st of December this year, we are going to see the removal of the effects of the general principles of EU law as an aid to interpretation in respect of legislation. And we're also going to see the repeal of effective EU rights so that they no longer have any effect as a result of the retained EU Law Revocation and Reform Act 2023. So what does that really mean for us? Well, it means that our law is to be effectively stripped of EU principles, and the special status of retained EU law in the UK will come to an end. And this means that going forward, therefore, judges will have to consider the meaning of the cases that they will be dealing with, excluding any EU principles. And to highlight this, and sort of to give emphasis as to why I think we are moving into a slightly turbulent period starting in 2024 and progressing onwards, is sort of highlighted by the Equality Act 2010 Amendment Regulations 2023, which come into effect on the 1st of January, as well as some other regulations that are coming in. And so I wanted to highlight to you using this, because what the Equality Act 2010 Amendment Regulations are doing is really ensuring that some key rights and principles in respect of equality law that derive from EU law are being safeguarded and implemented into domestic legislation. But what I think it highlights, and I'll demonstrate when I go through what's actually already we know about, but is it being brought into domestic law, is that there are obviously lots and lots of other areas relating to employment legislation where we don't have any regulations implementing certain principles, and where we may have and do rely on interpretation to EU law and what has been the existing norm. And so you can see that perhaps going forward, this is going to be problematic for us when we're looking at areas. So, for example, in respect of direct discrimination related to maternity and breastfeeding, under the current Equality Act 2010, women may be given special treatment in connection with pregnancy or childbirth. But we know that the current position under EU law is much more extensive than that and confirms that unfavourable treatment related to pregnancy and maternity amounts to direct sex discrimination. So actually, the current Equality Act doesn't give that protection in the way that the EU law does. So the regulations will insert maternity into the relevant provisions of the Equality Act to preserve this protection for women. Equally, currently, women can bring a direct sex discrimination claim if they are subject to less favourable treatment at work because they are breastfeeding. But the Equality Act, as it currently stands, expressly states that the provision prohibiting less favourable treatment due to breastfeeding does not apply to work settings. So again, the regulations will remove that provision in the Equality Act so that there will be the appropriate protection in place for women who still want to bring that type of claim. The Equality Act does not protect women who suffer discriminatory treatment following maternity leave because of pregnancy or pregnancy-related illness during maternity leave. But again, we know that EU law enables women to bring claims in those circumstances. So again, these regulations will be amending the Equality Act to ensure that women have this protection. The regulations will also provide equivalent protections against discrimination in relation to maternity leave under occupational or other contractual schemes as statutory maternity leave, where no comparator is required to bring a sex discrimination claim. In respect of disability definition, so under the Equality Act simply refers to the ability to carry out normal day-to-day activities, but the EU law focuses more on individuals' ability to participate in their working life. And so we're going to see that the regulations, which again come into effect on the 1st of January, will expand Section 6 of the Equality Act to include a reference to a person's ability to carry out normal day-to-day activities to be taken as including a reference to the person's ability to participate fully and effectively in working life on an equal basis with other workers. Under the Equality Act, in order to bring an indirect discrimination claim, an individual must possess a protected characteristic against which the employer's practice, criterion or provision is discriminatory. But in EU law, it permits an individual to bring an indirect discrimination claim if they suffer the same disadvantage, even if they themselves do not have the protected characteristic. And again, the regulations will now add that new provision into the Equality Act. Similarly, in relation to equal pay, the regulations will replicate the single source testing. But if we did not have those regulations coming into effect from the 1st of January, those particular rights would have all been lost as we moved into 2024. And so we have one other piece of legislation, the Employment Rights Amendment Revocation and Transitional Provision Regulations of 2023, which also come into effect at the beginning of January. And they're trying to try very hard to clear up areas in the working time regulations and 2P and to somehow give greater clarity to what has been a substantial body of case law probably over the last 25 years looking at working time regulations and 2P. So things that are highlighted here, which I think are helpful, but again, are being put into place and protected. So certain rights in relation, for example, to the carrying over of annual leave, where a worker's been on maternity or family-related leave or sick leave, will be protected. They're introducing the option of the rolled up holiday pay for irregular hours and part-year workers. And I think thankfully for many of us, allowing for an annual leave accrual method using the 12.07% of hours worked for irregular hours and part-year workers. They're also looking to simplify things like the consultation requirements under 2P for small businesses in particular. So if you have less than 50 employees, and then you have no other form of representation in respect of a union or an elected employee forum who've been constituted for that purpose, then you will be able to consult with with the affected employees directly. And similarly, any business of any size that might only be 2Ping 10 or fewer employees, you will be able to consult with them directly without having to go through the election of representatives. But those particular areas are highlighting again to us that there are other areas of employment law that haven't been dealt with. And so with the revocation of the EU law principles and us being able to reference back to arguments and principles that arise from EU case law, my prediction going forward into 2024 and beyond is that we are entering into a new and I think quite concerning area of employment law interpretation. So from that perspective, I think what it means for us with you is that we just need to update you more regularly than ever on changes in employment legislation, because there will be a change in the way in which cases are going to be interpreted going forward. And I think it's going to become an interesting and challenging time for not only employers, but employees and certainly for employment lawyers. So I wanted to sort of start a debate and get you thinking about that and how it might impact you going forward. I don't know if any of my colleagues are up for giving their thoughts on it, but I feel like we're on the cusp of quite a change going forward, certainly with employment litigation into 2024 as a result of, us losing everything to do pretty much with EU legislation and case law.
So, yeah, totally agree with you on that, Susanna. And as you said, it'd be good for the firm to do more webinars in 2024 as well, just to keep people regularly updated. So the plan was to do one every quarter. This year we may maybe do a couple more as when key things happen, because we were always very keen to keep all of our clients and referrers of work fully in the loop with everything. So yeah, and unless anybody else has anything to say, I'm conscious of time on the webinar as ever, so we've got other things to cover. Okay, no, that's good. Susanna, that was fantastic. Thanks so much. And handing over quickly to Don, who's going to discuss some changes to flexible working.
Thanks, Dean, and good afternoon, everyone. Mine's a slightly shorter piece, but as Dean mentioned, I'll be talking about future amendments to flexible working. So on 20th of July 2023, this year, the Employment Relations Bill, or the Flexible Working Bill, received royal assent. So this will result in several changes to the current flexible working regime through the Employment Relations Act of 2023. Firstly, an employee will no longer have to explain what effect, if any, their flexible working request would have on the employer and how this can be dealt with. Secondly, an employer can no longer refuse a flexible working request unless the employee has been consulted, although there's no current guidance on what a reasonable consultation would entail. Thirdly, all flexible working requests have to be decided within 2 months of receipt, as opposed to 3 months that it is currently, but it would still remain open for both parties to agree to an extension. And fourthly, an employee will now be entitled to make 2 flexible working requests in any 12-month period. Furthermore, although this was not one of the amendments in the Act, the government did initially reference the right to make a flexible working request becoming a day one right. As you may know, it currently requires an employee to have 26 weeks continuous employment. But more recently, the flexible working regulations of 2023 were laid before Parliament this week on the 11th of December 2023, and it comes into force on the 6th of April 2024. So the amendment revokes Regulation 3 of the flexible working regulations, which requires an employee to have been continuously employed for a period of at least 26 weeks. So therefore, there will be no length of service requirement in order for an employee to make a flexible working request on or after 6th of April 2024. The regulations apply to England, Scotland, and Wales. So none of the changes will prevent an employee from bringing an informal flexible working request. And on 20th of July 2023, the Department for Business and Trade issued a call for evidence on non-statutory flexible working. The government intend to use this evidence to support its approach to flexible working. The call for evidence closed last month on 7th of November 2023, and the responses are intended to help the government's evidence base on non-contractual flexible working and assist their future flexible working strategy. Both ACAS and the Trade Union Congress have published their responses, which are available online on their respective websites. The government expects these changes to come into force approximately 1 year from the bill being granted royal assent, so July 2024. This will give employers an opportunity to consider how they can prepare for these changes. This may include updating policies and employee contracts, ensuring all members of staff are aware of the upcoming changes. It should be noted that any request prior to the Act coming into force will be included for determining an employee's number of requests over a 12-month period. Of course, if you would like any assistance with what I've discussed, then myself or another member of the team would be more than happy to help. Thank you.
Okay, that's great, Dom. Thanks very much. I can see that we've had a question. Which has been answered. Okay, sorry. So Rosie's asked a question that Susanna's currently dealing with, I think. That's great. Thanks so much, Susanna. Again, conscious of time, I really appreciate that, Dom. Moving on to Carl, who's going to discuss some changes to do with post-termination restrictions. Over to you, Carl.
Hello, everyone. Thank you for joining us. So I'm talking about what appears to be the latest UK government's visitation of a question that it raised back in 2016, and it's been here before, so to speak. But this is in relation to the UK government's wish to legislate in the future to limit the application of non-competes. That's a form of post-termination restriction. There are other forms I'll come on to in a moment, but to limit the applicability of a non-compete to 3 months and no more. And so basically, on the 10th of May of this year, the government issued a policy paper called Smarter Regulation to Grow the Economy. It's available on the www.gov.uk government publications website, and it's a brief summary. It does touch on the cheapy points that Susanna mentioned earlier, but it seems to be that it's now made a decision that after years of considering various permutations about how to encourage businesses to innovate, businesses to be able to hire those who have left other organisations to join them and not be restricted in the talent pool, so to speak, by the application of non-competes, that it actually just wants to ban non-competes, the applicability of non-competes to 3 months post-termination. I just want to pause and reflect on some of the considerations that were raised back in 2016 when this was raised by the government, because I think they remain applicable now in response to this recent announcement this year about this proposed limit to non-compete. And that was that if the aim is to encourage innovation, the concern was that if you actually ban non-competes altogether, some people who would rich investors and backers would be reluctant to invest as much money in the UK, because the risk was that someone that they invested money in, they trained and upskilled, who had confidential information, may just then go and join another startup or another competitor straight away. And I think the government's taken that on board, and they're not planning to ban non-competes. They're just going to limit their period of restraint to 3 months. But the view was then that as one reaction to limiting it to 3 months, businesses naturally would want to try and protect the same interest that was going to be protected by non-compete. And that generally is the wish to prevent an ex-employee from disclosing confidential information to a competitor. The most effective means to do that is to have a non-compete, because it's very difficult to police the alleged leak of confidential information simply by relying on existing confidentiality obligations in a contract or the implied duty of confidentiality in law. So non-competes serve that very useful function. as a reaction to this limit of 3 months, some employers may decide to introduce longer notice periods in employment contracts for staff members, and also consider garden leave provisions, making sure their employment contracts have garden leave provisions in them. So you effectively prevent the employee from working for any other entity during garden leave, because during that period of time they remain employed, they remain subject to the implied duty of fidelity and certain other express terms of contract. However, the problem might be that you have to weigh up, if you're going to do that as a business, you have to weigh up how long the garden leave is going to be for, how long the notice period is going to be for, because there's obviously a cost involved in longer notice periods, and whether the cost involved is still outweighed by the benefit in locking the employee out of the competitive market, so to speak. You have to sort of weigh these things up. The other thing to bear in mind is that if you do have a longer notice period to try and counteract the effect of having a non-compete that can't be longer than 3 months after they leave, what happens if the employee misbehaves or commits misconduct or gross misconduct? It will probably be quite distasteful to keep that employee employed on garden leave in full pay and benefit, receipt of full pay and benefits against the background of their bad behaviour. You may then decide that you simply aren't going to maintain that position. You're going to take disciplinary action. Depending on the circumstances, you may dismiss them and then just rely on the 3-month non-compete kicking in at the date of their dismissal, and knowing then you can't go for a longer period of restraint. Now, the proposal is that this non-compete will only apply to employees and workers in their employment contracts or worker contracts. It won't apply more broadly to other forms of contracts, for example, shareholders agreements. It won't apply in investors agreements or asset purchase or asset transfer agreements. That's good news in my view, because of the point that people enter into different contracts with different statuses in law, different hats on, so to speak. So I'm acting for a matter at the moment, the firm is, on behalf of 2 entities, 2 claimants suing 3 defendants in the Chancery Division of Business Property Courts, because we say that 2 of the defendants breached obligations in the form of a non-compete in a shareholders agreement, subject to different considerations to those that apply into the enforceability of non-competes in an employment contract, and they're also in breach of other obligations they owed as an employee, separate from their status as shareholders. I think what remains unclear is the full contours of the scope of this new restriction on the length of non-competes. So what I mean by that is, if it applies to workers, but it doesn't apply to partnership agreements or LLP, limited liability partnership agreements or shareholder agreements. Well, we all know from the Clyde & Co. LLP and Bates van Winkle decision, in the context of whistleblowing detriments, a member of an LLP is also a worker. So one has to see the extent to which, if there is going to be a non-compete that lasts longer than 3 months in an LLP agreement, or some other form of agreement that person's a party to, the worker's a party to, will they be able to rely on this proposal to reduce down the longer period of non-compete to 3 months and wriggle out of what actually was a longer period of restraint that they voluntarily signed up to? So that remains to be seen. There appears to be a sort of growing falling out of love with non-competes. In June of this year in New York, there was a decision to ban non-competes in employee and workers contracts. I think that was waiting for the mayor to sign. It was on the mayor's desk, so to speak. And California has restrictions, has banned it in employer and worker contracts as well. There's a US Federal Trade Commission rule that's banning non-competes. I think there is some article I read that it's still unclear in the US the extent to which there's going to be litigation challenging the ability of the US Federal Trade Commission to bring that rule in. I think the key points that I want to raise are that it's always a good idea, regardless of this proposal, because we don't quite know when it's going to be brought in. It might be next year. The government has said it's when parliamentary time allows, and they've got other things on their plates, obviously. So we don't quite know when it's going to be brought in, but it's always healthy and good at the beginning of the year, I think, especially if you're considering a pay rise to any of your staff, especially those staff who you think could represent a bigger competitive threat if they leave because of the confidential information they have access to and their ability to influence customers and clients, etc. To look at the contracts and decide whether it's time to refresh those restrictions. As things currently stand, the general position remains the same, which is that all post-termination restrictive covenants are unenforceable in law, except to the extent that they go no further than is reasonably necessary to protect a legitimate business interest. So you can have non-competes that last longer than 3 months. I have seen them as short as 1 month. I've seen them as long as 2 years. And I think it's good and healthy to sort of refresh and decide whether, if you're actually going to award a pay rise, is it a time also to revisit the precise wording of your covenant so that they better reflect how you want to try and protect your business interests. This proposal from the government won't apply to non-solicitation of customers or potential customers, or non-deal with such persons, or non-poach of employees, or non-interference with suppliers. Those other forms of post-termination restraint aren't going to be affected by this proposal. And also, the government has said that this proposal won't apply to what's called indirect non-competes, i.e. other provisions such as forfeiture of shares or having to repay a bonus or training costs that the employer has been invested in an employee if the employee leaves within a certain period of time and joins a competitor or any other entity. So those more subtle forms of deterring employees from leaving won't be subject to this law. But I think the precise contours of it remain unclear. We have to see. We'll keep you updated if we have any update in that regard.
Great. Thanks very much, Carl. And obviously, one of the services that we offer is contract reviews, and help our clients update and to the best extent that we can create fantastic restrictions to really try to maximize the chances of these provisions being enforced by the courts, which are super helpful to protect the business, as Carl's just said. So yeah, that's great. Thanks so much, Carl. And moving on to a final section before the quiz, handing over to Jess, who's going to speak about the Worker Protection Bill. Over to you, Jess.
Thanks, Dean, and good afternoon, everyone. As Dean has said, I will be talking about the new Worker Protection Amendment of Equality Act 2010 bill, which received royal assent on the 26th of October this year, is therefore due to come into force in October 2024. So the Act makes a significant change to the law on the employer's obligations to protect employees from sexual harassment. Whilst it has been watered down compared to the original proposals, the new law will create an important new duty that employers do need to consider. So what is the new law? The Act will introduce a new duty to take reasonable steps to prevent sexual harassment of employees in the course of their employment. This applies to sexual harassment as defined by the Equality Act, which means unwanted conduct of a sexual nature. Although the law has primarily been introduced to protect women, it will apply to people of all genders. So currently the law already provides a defence to a harassment claim if the employer can show that they have taken all reasonable steps to prevent it from happening. It has therefore been advisable to take such steps, but there has been no requirement to do so. The new law, however, goes further by placing a separate legal obligation on employers to take proactive measures to prevent sexual harassment. It's important to note that the new duty only applies to sexual harassment. It does not apply to harassment based on other protected characteristics such as race, age, sexual orientation, or belief. It also does not apply to harassment which is related to sex but is not conduct of a sexual nature. So what is the meaning of reasonable steps? There's actually no guidance on what is considered to be reasonable steps in the new law. However, the employer's defence in the Equality Act uses similar wording, that the employer took all reasonable steps to prevent the discrimination or harassment. The word all was actually removed from this new duty during the parliamentary process, meaning that it is a somewhat lower threshold than initially intended. Nevertheless, it could be that employment tribunals will interpret this in a similar way to the existing employer's defence. By way of guidance in the employment tribunal decision of Fisher and London United Busways, which related to workplace discrimination against a trans person, the court considered in some detail what would be expected of an employer to show that they've taken all reasonable steps. In this case, the employer did have appropriate policies in place. However, they failed to take other steps, such as keeping these policies up to date, making them available to all staff, and implementing regular training. So how will the new law be enforced? So it will be that a claim for a breach of the new duty can be made in the employment tribunal. However, it will not be a freestanding claim and it must be attached to a claim for sexual harassment, similar to a failure to follow the ACAS code being attached to a claim such as an unfair dismissal. If an employee succeeds in a claim for sexual harassment and the employer is found to have breached its duty to take reasonable steps to avoid the sexual harassment, the Employment Tribunal will be able to award a compensation uplift of up to 25%. The duty can also be enforced by the Equality and Human Rights Commission using its existing powers of enforcement, which include investigations. The Equality and Human Rights Commission has also indicated that it will update its technical guidance on sexual harassment at work to reflect the new duty. So how can employers prepare? Although, as I've said, the law does not change until October 2024, it is advisable to take steps now to ensure that companies are well placed to show that they have taken reasonable steps to prevent sexual harassment. This will also help show that you've taken reasonable steps to prevent harassment of any kind, which can obviously defend those claims. Some key steps to take, or at least to consider in the new year, would be to update anti-harassment policies and ensure that policies focus on inclusion as well as equality, to create a central reporting register for complaints about all forms of harassment, to conduct targeted risk assessments to identify risk factors and then assess what action can be taken. And then finally, ensuring that there is a clear avenue for reporting complaints about harassment and that all of these complaints are taken seriously and dealt with effectively. Back to you, Dean.
Hey, that's great and very clear. Thanks so much, Jess. Okay, that brings us to the end. I can't see any questions from the attendees. So that brings us to the end of the legal update part of the webinar. Just a quick reminder that everything that we've discussed is accurate as of the 1 o'clock on the 14th of December 2023. As I'm going to stop recording in the moment, for the people online, have a fantastic Christmas and a very happy New Year. For those that are live with us, please do stay on with us as we're going to do the Christmas quiz. And of course, if you find these webinars useful or like using us as a law firm, feel free to recommend this to others. We very much do like having referrals, which are great. And yeah, just finally, have a very Merry Christmas and a Happy New Year. And we look forward to continue working with you in 2024. Thanks and take care. Bye-bye.